So, two issues, two controversies, so two topics tonight on TVJ, all angles. Thanks so much for being with us. I'm Dion Jacksmiller. Now, later in the program, we're going to talk about developments of the past 24 hours since a long-awaited tabling of the legal opinions from the Attorney General about how reports should be tabled in Parliament. But before that, so do we have a Director of Public Prosecutions and an acting DPP? Or do we just have an acting DPP? The situation is still far from clear if you look at the government's position and the government statements and what are the implications. We're joined in this section of the program by the president of the Advocates Association, Leonard Green. Adley Duncan is joining us on Zoom from Bermuda. He's Crown Counsel there. He's a former Deputy Director of Public Prosecutions, attorney at law, and a representative of the Bar Council of the Jamaican Bar Association. Gavin Goff is with us, and Jodianne Quarry, international human rights lawyer and a member of the RGR Gleaner family, one of our hosts of the morning show, Morning Agenda on Power 106. Thank you all so much for talking to us. Great to have you all on. And to say, just a reminder, we're talking English, not legalese, anybody. So let me just start off just by backing up a little bit. And let me see, Jody, let me ask you to take this first. The importance of the office of the DPP and why we're all talking about the office.
You're talking about the bulwark in the country. When you talk about crime, when you talk about violence, people want to be able to see some sort of solutions. You're talking about a constitutional office that exists for the person who initiates prosecutions, who can intervene in prosecutions, who can end prosecutions. They have responsibilities for mutual legal assistance treaties, giving advice to the government, but also they are a voice for the people. They are the person who, when you hear their reasons, and something that Paula Llewellyn was very good about, was helping the country understand reasons for prosecutions or declining to prosecute. This helps people be more involved in our justice system and in the process that we have. And so I think it's really important then for us to understand the critical nature of this role and then why the confusion around the role is so important in the very fabric of Jamaican life.
And Gavin, we talk a lot about the independence of the DPP and why is that important and why is that a thing?
Well, I mean, the justice system, of course, is founded on being an independent one. That it's independent of the political arm of government, it's independent of the executive arm, it's independent is independent of the politicians who are responsible for appointing him or her. Is an integral part of our constitutional framework. And so when we're having this, I guess you could call it a political battle in courts over a position which is independent, it certainly doesn't make us feel comfortable.
And Leonard, so why we're talking about this case? Why is this case important?
Simply because the Director of Public Prosecution is arguably, if not the most important, public officer, is a very, very powerful officer, an officer who has the power to stop any prosecution before judgment. That officer is one who determines, is really the engine of the whole criminal prosecutorial system. And her importance has captured the imagination of so many Jamaicans. Yesterday I was in Westmoreland, and the lady in the hardware store asked me, what do you do with Miss Paula? And you know, ordinary Jamaicans are very concerned about this particular office because of the power. A Director of Public Prosecution can only be removed from office in cases of infirmity of body or mind, or
Meaning sickness.
Sickness, yes. And also for misbehavior. Apart from that, can't be moved. And she's exempt as a public officer from the Public Service Commission. She is not subject to sanction from that body at all. And that's the only public officer who has that privilege.
All right. Now, as I mentioned, we have Adley Duncan joining us from Bermuda. Adley, just before I bring you in, though, I've just been sent another statement from the Jamaican Bar Association calling for clarity in the appointment of the acting DPP. So I'm just going to ask Gavin just to explain for us what this is saying.
Sure. So the announcement of the acting DPP comes on from the Constitution, where it says that if the office of DPP is vacant, or if the DPP is unable to act owing to infirmity, or unable to perform her functions owing to infirmity, then an acting DPP can be appointed. So, of course, the question is, which one of those two premises was the basis for the appointment of the acting DPP? Based on the statement from the government, it would appear that they are saying that Ms. Llewellyn continues to hold the post, but is unable to perform her functions at the moment, and that is the premise. But
right, they've literally said that she has advised that she's unable to carry out the functions of her office at this time.
Right, her office part is the part that I think begs the question as to whether it really is her office at this point in time.
So you want clarity on whether the government believes she's still DPP?
Whether the Public Service Commission is making this appointment on the premise that she is still the DPP.
Why is that important?
Well, it's important for a number of reasons, especially because we need to understand, firstly, whether the appointment itself is valid, and the reasons for it being valid. Because if it is that it is
meaning the appointment of the acting
DPP.
Wow.
Because if you're appointing the acting DPP on the premise that, in fact, there is a DPP in the position, when in fact there isn't a DPP in the position, that itself not only leads to further uncertainty, but it could also actually add questions as to whether or not this appointment itself is valid. So there are a number of reasons why we think it needs to be made very clear.
Wow.
well, the fact is...
Comment, I was going to bring in Adley, but I think he may have disappeared on me for a little, so while I bring him back, comment from the other
Yes,
guys.
the fact is that the ruling of the court was clearly unclear. And there are a number of things we need to look at. Because at the end of the day, we didn't get a sense that there were clear directions as to what would happen immediately after this judgment was delivered. And that is a problem. Hence, it invited a situation where the government says, well, let us clear up a few things. In a perfect world, after the judgment is written, persons would be absolutely clear about where we are. This, unfortunately, was not the case after this judgment was delivered.
And just to make to emphasize what you're saying, it can be that the court has said X.
Yes.
We don't agree with X, so we're appealing.
Yes.
But really and truly, after this judgment, we don't know what the court said. Well, some people purport not to know what the court said.
But why do we not know what the court said? The court says in paragraphs that the section that talks about the extension of time doesn't apply to the holder of the office because she had already been retired. It says that the extension that she had received with the agreement, or rather with the consultation between the Prime Minister and the Leader of the Opposition, gave her an additional 3 years. It said that the provision that was created in July of 2023 doesn't apply to her because she is unable to meet the process that the Constitution still continues to set down in section 96(1). The lack of clarity is a line that would say, and so she does not sit in office, but nothing in that judgment leads us to believe that at the end of it she continues to sit in office.
Well, that's what you say, but that's not what the government is saying. Go ahead, Gary.
Well, I think part of the reasoning from the government is that there was a request in the particulars of, well, in the court documents, there was a request.
You're trying, Gary.
I'm trying. There was a request in the court documents for an order that the amendment does not apply to the incumbent DPP.
Amendment being the constitutional amendment that extended the retirement age.
Exactly. So there was a specific request for an order in those terms, and that order was not made by the court. And therefore the argument is the court, having had the opportunity to make a specific order to say that, it's not sufficient for them to actually say it in the body of the judgment if they don't actually go and make an order itself that says it does not apply, especially because you asked for it.
But small difficulties like that can be quickly remedied by the court. Oh my goodness, forgot to put that line in it, the word disappeared, we can put that in, we can make that order. Further directions can clarify this, give us the additional detail that you need, if that's the only line there or the only thing there that's making the difference.
Well,
why not ask for that?
Thing, though.
Of course, the grounds of appeal, they're 17.
Look at the confusion.
Hold on for me. Let's go to the break and we come back. And hopefully when we come back, we'll link with Bermuda as well. We'll come.